Hello and welcome to the Siam Center Law Group podcast, where we break down legal concepts into clear, usable knowledge to help you handle any legal situation with confidence. Today, we're diving into a powerful technique that every lawyer should master, especially during cross-examination in court. Yes, we're talking about how to use documentary or physical evidence in cross-examination, a strategy that can be a real game changer in litigation. Can documentary evidence be used without submitting a witness list? The answer is yes, but there are conditions and it must be done correctly. Normally, to use any form of documentary or physical evidence in court, whether in civil or criminal cases, you must include it in the witness list submitted to the court. However, if the opposing party calls a witness to testify in court, and you then use that evidence during cross-examination, and that witness acknowledges or confirms the evidence, then the court can accept that evidence into the case file even if it was not listed beforehand. Real-world examples of such evidence: a contract previously signed between the parties, chat logs from line, or Facebook photos or video clips related to the case. If the witness admits to having seen, used, or been involved in the content of that evidence, it is considered valid and can be entered into the case record. Two key legal principles to keep in mind. First, what counts as witness confirmation of the evidence? The witness confirms the existence of the evidence. The witness has seen the document or material before. The witness admits their own signature, voice, or image appears in the evidence. If any of these apply, the court may accept the evidence into the record. Second, what does not count as confirmation? The witness denies ever seeing the document before the witness doesn't believe the evidence is genuine. The witness denies involvement, such as not signing, not being in a photo wash video, or not having any connection to it. In such cases, the court cannot admit the evidence, even if the opposing lawyer tries to use it in cross-examination. Additional note: criminal cases. In criminal cases, even during the preliminary hearing, inquiry phase, if the prosecution witness acknowledges or confirms the evidence during cross-examination, the court can accept that evidence into the record. This principle applies to both civil and criminal proceedings. Pro tip for defense lawyers: if you're representing the defendant and the opposing counsel uses documents or other materials to cross-examine your witness, but your witness does not confirm or acknowledge the evidence, you must object immediately. Do not allow the court to accept the evidence without protest, as it may severely weaken your position. Thank you for listening. Goodbye.